So what I'm going to talk about is a very brief overview of wage and hour. So some of the wage theft issues we see most commonly and that I imagine would be most helpful or relevant to you all if you're taking these cases through clinics. And then we're also going to talk about some of the basics related to Washington safety and health laws. You can imagine always an issue, but right now a ton of people asking us questions about how to stay safe, what their rights are, when they can decline to do work, that sort of thing. And then I'll also just talk a little bit about some enforcement processes for those two areas, particularly focusing on the Department of Labor and Industries, because I imagine that that will be one of the resources that you all would direct people to through the clinic consultation process. So I want to give you a basic idea of what that looks like to assist you in providing information to workers. Feel free to drop in questions, or I guess we might have a designated time, Michael, at the end. With that, I think it goes without saying, hopefully, there's a lot of different legal protections that fall into what we call wage and hours. So that's what you can think of as like wage theft, minimum wage, overtime, anything about how you get paid. And I'm highlighting just some of the ones that I think come up most commonly for workers. And I tried as much as possible also just to include some of the references to the statute and the regulations to the extent that that's useful for you if you want to do some follow-up. So a really common topic we talk about with people is what minimum wage is. So folks may know that we have a state minimum wage of $13.50. But we also have some localities in the state that have higher minimum wages. So it does depend on where people are. And in Seattle, it also depends a bit on the size of the employer. Some important things to know is that people can never agree to get paid less than minimum wage. That's something that we see very frequently. And sometimes people are told that because of the amount of experience they have, or perhaps their immigration status, or being in some probationary period, that automatically means that they get paid less. It's not true. We also often pretty regularly see people who agree to a flat rate for a period of time. So I get paid $1,000 a month. $1,000 a month might meet the minimum wage standard depending on how much I work. But very likely it doesn't. And so oftentimes people don't know that flat amount may not be meeting the minimum standard. Something to know about Washington law is that tips, so if people work in restaurants or other settings where a big part of their income might be tips, in other states, tips can be counted into that base pay, and in Washington it can't. So that's also something that there's a lot of confusion about very frequently, and a place where we see people get taken advantage of. So minimum wage, for sure, important to be asking people what they're doing and how much they're getting paid per hour, and then really breaking it down, like do the math. What's their average schedule, and see what that looks like, because we have seen pretty egregious rates of pay pretty frequently. Okay, overtime is probably something else that you are familiar with or have heard about. So overtime is for people who are paid hourly, so not salaried. I didn't flag it here, but our overtime cap is changing right now. So I'm happy to share more information about that. But it's a general matter for hourly workers who work more than 40 hours in a 7-day work week. The law is flexible. If it's Sunday to Saturday under the law, unless the employer says it's something else, but it's 7 consecutive days. It's not about the amount of hours you do over the pay period. That's something that happens very commonly. If I get paid every 2 weeks, people will say, well, I worked 50 one week, but 30 another, so I am not entitled to overtime. It's 80 altogether. So it's by week. And this is not something that depends on where you are, and it doesn't depend on how big the company is that the worker works for. So like minimum wage, this is not an optional benefit. People can't agree to get paid less. And under the statute, it's at least 1.5 times their regular rate. And that, again, depending on how much information people have about how much they're getting paid and what their schedule is and all of that, sometimes it's a little unclear what that base rate is, but it's at least 1.5 times that. So something else that everybody is entitled to around the states. Here are some other common rights that we see violated very regularly. One is the right to be paid for all hours that you work. That might sound obvious, but we very regularly see people who find missing hours on their paychecks, or who are told, all right, clock out at 7, but we need you to finish cleaning up for like another 20 minutes. So that's time worked. And so we see very frequently those 15 to 20 minutes over the course of a month or a year, that's a significant amount of time that people aren't being paid. And that time, when you add it up, oftentimes makes people overtime eligible as well. So the right to be paid for all the time you're working. To get all of your tips or gratuities or service charges as the law dictates, and to get that at the same time that you get paid. So if I get paid every 2 weeks, my tips for that pay period should not come several weeks after that. It should come with that base pay for that period of time that I'm getting paid for. Something else that we see very commonly as a problem is people getting paid on time. So people have the right to get paid on a regular schedule. Under the regulations, that means at least once a month, but it depends on what the practices are at the company to pay more frequently. So whether that's biweekly, every week, but people should get paid on a regular schedule and get paid on time. We have case law that says getting paid late is the equivalent of not getting paid at all, because of course it does have a tremendous impact to the person who is not getting paid. So we see this a lot with delays, people saying, oh, I'm going to get it to you in a few days, bounce checks, people getting part of their payment for that pay period, but not the whole amount. So all of those are violations of getting paid for all hours that you've worked and getting paid on time. And this is really important because in particular, working with low-wage workers, and certainly now in the context of the pandemic and recession, there are a lot of people who feel like, I really need this job. I just have to get the check when they're going to give it to me. And it's just not the case under the law. So that employer obligation is the same no matter what. People also have the right to get a pay stub each period. So this is another thing, the amount of people who get just a flat amount with no itemization. So you want to be able to see how many hours, how many, like what's the rate of pay by hour somebody's working? What have they taken money out for? So deductions is not something that we're going to talk a lot about today, but there is guidance about what employers can deduct for and what they can't. And it's very common to see people charged for things and to have that money taken out of their check when it's not permitted. So something to be aware of when you're talking to people about how they're getting paid, how frequently, and what documentation they're getting that explains to them why they're getting paid what they are. And then I included just the citation to the statute that is the double damages provision. So there's a provision that says that people are entitled to twice what they would be owed when there's willful failure to pay wages. And so that again depends a lot on the situation, but we regularly see companies that are very aware or have been put on notice by the employee or potentially by one of their coworkers about the problems with their pay and continue to do it. And so be aware that the law does provide for additional penalties for workers who are taken advantage of in that way. So when we think about how people get paid, we usually think about the money they're getting, but their breaks are also a component, a really important component of the minimum standards that we're focused on protecting and enforcing. So meal and rest breaks, people are entitled to in different ways. So meal breaks, people are entitled to if they're working at least 3 hours, and it should be at least a 30-minute break. Meal breaks, if they are true meal breaks, are not compensable time. So that means that people don't get paid for that time. But I tell you that in part because it is one of the most common conversations I have with people. What is it that you're doing during your lunchtime? Because what I find is people frequently have a break, but they're expected to come back as soon as somebody needs them. If they're short on the cash registers, if the store gets busy, if a customer needs something. And so that's not actually uninterrupted time as the statute contemplates. And so if it's not uninterrupted, if people have to stay at work, they have to stay on site, that time needs to be paid, because it's not really a break as anticipated. And so they have to be paid for that time, and that time also does count towards how many hours they're working in a week and if they're eligible for overtime. So meal breaks is a place where I would say we see tons of violations. And rest breaks is another place where we frequently will have conversations about people walking us through their schedules. And rest breaks are also something that people very frequently are told they can't take, or in practical terms are not permitted to, because of the type of work they do, the schedule, the output that they're expected to complete in a certain shift. So people should get at least a 10-minute break every 4 hours, and that time is paid. And so there will often be confusion too about if people are entitled to payment for that time. So meal and rest breaks, something else to be sure you have on your radar. And we typically, when we start a consultation, people just ask them to walk us through their whole schedule, start to finish. What is your day like? And you'll find a lot of information about meal and rest breaks for sure, in addition to other issues in the course of that conversation. Okay, other things to keep in mind. The burden's on the employer to keep employment records. That includes timesheets, that includes their pay stubs, that includes documentation about practices, discipline, anything that might come up. And I think this is really important because a lot of workers, they come to us and they say, well, I don't have any proof that this is happening, but this is what happened every day. And or I got paid in cash and I can't prove it, but I was only getting paid $200 a week. And that actually is not their responsibility. And so I think it's important for people to know that, because it can be a serious impediment to people feeling like they want to file a complaint or perhaps pursue some remedy they have, as they think that it's solely on them to prove what was happening. Many of you are probably already familiar with this, but I did just want to mention briefly that Washington, like most states in the United States, is an at-will employment state, which means that absent a union contract or some other agreement to the contrary, people can be fired at any time for any reason or no reason at all, as long as that reason isn't discriminatory. And I mention that to say, oftentimes people will come to us and they say, what I want to talk to you about is like, they fired me and they didn't tell me why. And unfortunately, that by itself is not illegal. But oftentimes when we start the conversation about how the job ended and we start talking about what it was like before, you'll find that there were a lot of other practices that might be legal violations that were also going on. And even if someone is fired, they're entitled still to be paid for all the hours that they worked, and actually to be paid by the end of that pay period that included their last day. So it can't be that they have to wait 2 months or their pay is withheld until they turn in their keys or something like that. So something else we see a lot. Okay, a couple other things I just wanted to share as you're talking with people about how they're getting paid, their breaks, their schedules. What we're talking about right now are obviously just the legal minimums, right? And today we're not even getting to hit on all the legal minimums, but some of the ones that we see most frequent violations with. Employer practices can always go beyond the minimum. And one of the most common scenarios we think about is when people have a union, and a union has a collective bargaining agreement that has imposed additional obligations or higher pay standards. So it's super important to make sure you know if somebody has a union or not. Discipline procedures, protections from firing, that kind of thing. But also employers have other practices, and those practices are really important because there might be obligations that the employer has committed to that are reflected in hiring practices, in employer manuals, in other, the employment agreement. Sometimes people get a written agreement even though they don't have a union. And so it's important to ask people if they have those things, if they ever got them, because you don't know what you might find in there that could be helpful. That explains when raises are supposed to happen, for example, or something about a policy related to paying out PTO or vacation time. And so when people come with questions, before we start telling them what, we don't want to just give them advice based on what the minimum standards are, because it is possible they were in a workplace where they had some additional benefits. So make sure you ask. And the last thing I just want to mention, just other considerations, is classification. So many of you probably know misclassification of workers as independent contractors as opposed to employees is a very common practice. And it's important because the standards I just talked about only apply to employees. And so a lot of these protections really hinge on that classification. Someone just being called an independent contractor does not make them an independent contractor. And particularly when we talk about lower wage workers, many of those people are oftentimes actually properly classified as employees. But I mentioned that because it is something that's important to have a good sense of as you're giving people an idea of what their options are with respect to the issues we just talked about. And also it's one of those places where there might be a lot of confusion or misinformation that's been given to a worker. And so they might also come presuming that something is off the table for them because of the information that they've got. So, okay, the last thing I think about minimum wage and wage an hour. Oh, there's a question. Cool. Is what the law says about protection from retaliation. So lots of our Washington state statutes explicitly have anti-retaliation provisions in them, including the Minimum Wage Act, which in addition to a couple other statutes is what covers all the different rights that I just talked about. So enforcing people's rights can look like filing complaints. It can also look like approaching your manager individually or potentially with your coworkers and saying, we don't like this practice, or we aren't getting paid our full hours. And so retaliation can be any adverse action. And so that really depends on the situation, what that can look like. But if it's one of those places where your intuition probably gives you a sense of what types of things we see most frequently. So I included some examples. Withholding pay, I actually see this very regularly, even in conversations where people are saying, we have proof you're withholding our pay. Firing somebody, demoting them, denying them a promotion, changing their schedule, taking their hours away, giving them hours that are less desirable or hours they can't accept or hours where they're going to get less tips. And certainly threats that are more directed at the individual's person status. And a really common example that we see is threats based on immigration status and perceived immigration status. Super common, all constitute retaliation. So when we talk to people about what happened, it's important also to ask them, like, how do they respond? Sometimes it's something they say to you directly, and sometimes it's something that they have said to one of their coworkers. So, and often actually, even in situations where we have very limited records in terms of pay stubs and timesheets and that kind of thing, many of you maybe have also had experiences where it's pretty shocking what people will put in a text message. So we have, sometimes we'll have communication in writing, sometimes through another coworker where some of that retaliation takes place. So that's an important thing to talk with people about. And sometimes those things have happened so frequently that people don't even necessarily conceive of them as specifically related. Sometimes it's very obvious, but just to say, sometimes there's some information you can get just about what the employment relationship was like overall, that can give you an idea that there might be some retaliation happening. Okay. There's a couple different enforcement options. We're going to mostly talk about the labor and industries complaint process at the end. Definitely an option. I'm also going to mention, we talk about that small claims court is an option for people who have wage theft issues. And it's one that I think we should explore more. And then of course, obviously people have the right to file a lawsuit privately with, or negotiate directly with their employer. So I think what I'll do, if it's okay with people, is I'm just gonna keep going through the initial things and then we'll get to the questions at the end, but I appreciate all of them, and yeah, lots to talk about. So the other area that I wanted to try to give just a brief introduction to is safety and health law, because it is coming up so often. I am sure that if you volunteer at any clinic, you will have people asking you questions. And safety and health, like I said, is certainly a long-standing issue, but has become really, really like at the top of people's minds lately. And so I'm going to talk mostly about our Washington State safety and health statute, but there's a lot of different legal guidance and potentially some other areas of law that are helpful for people who have safety and health issues or concerns. So hopefully when we have Colin and Allison talk, I think there's some aspects of like discrimination law and accommodations requirements, for example, in addition to some of the other guidance we've gotten in the context of the pandemic that may be helpful. But to start, let's talk about WISHA. So WISHA is the Washington Industrial Safety and Health Act. People may be familiar with OSHA, which is our federal counterpart. OSHA lets states basically pick one of two options. They can either just use the federal health and safety law, OSHA, or they can decide to create their own state counterpart. So that's what Washington did in 1973. We just have to stay as good as OSHA as like our floor. But so we decided to have our own system, which also means we have our own enforcement agency. So WISHA is enforced, and the regulations come also from the Department of Labor and Industries, which also enforces the Minimum Wage Act, which I should have mentioned at the beginning. And it's a different division. It's the Division of Occupational Safety and Health, or DOSH. And this is really important right now because folks may have seen that OSHA has basically I think it's fair to say abandoned its enforcement responsibilities in the context of the pandemic. They've said specifically they're not going to do enforcement actions. There is guidance that has come out, but in terms of enforceable, more directly enforceable steps, there's not a lot coming from the federal safety and health agencies right now. So the fact that we in Washington have another resource is really important. It's an important tool for workers here. Okay. So there's, as always, there's sort of some, what you start with, who's covered and what does it do, right? So it's RCW 49 that's going to have, 4917 is going to have everything related to WISHA. So broadly speaking, it covers all workers. So this is different than what I just explained with the Minimum Wage Act, where it hinges on classification. The definition of who's an employee for WISHA purposes is quite expansive and actually explicitly includes independent contractors. So that's important. As always, there's some exceptions. I think most relevantly, federal employees, tribal members are going to be using OSHA instead of WISHA. But by and large, most workers in Washington are going to have WISHA as a tool for them. So what does WISHA say people have to do? There's a general duty to keep a workplace free from hazards. So there's a general obligation on employers. And that general duty is what we're going to go back to when there's not more specific guidance that's been issued. And so DOSH also has put out what they call standards, which are specifically enforceable guidelines by industry, and there's also a set of what are called core rules, which are further elaborated expectations, legal requirements for employers in Washington. So general duty is like our catch-all. The core rules are more detailed guidance that are not industry specific. And I didn't pull out all of them, as you can imagine, but I pulled out some of the ones that I think are most relevant, again, to the types of questions that we see. And there's a general, there's additional guidance about workplace free from recognized hazards. So that means when you know that there's something dangerous, a piece of equipment, or maybe something environmental, obligation to address it. To keep workers from going into a work site that's unsafe or using tools or equipment that's unsafe. There's a core rule around establishing, supervising, and actually enforcing rules that are effective in practice. And when we go through these, I mean, I'm sharing them because these are the ones that I actually think they're obvious, but they're very routinely violated. And how they're violated can sometimes be quite specific to the type of work people do, but overall, frequently hear people telling us that these things weren't happening before. And now in the context of the pandemic, in a lot of situations, it's actually gotten worse. Controlling biological and chemical hazards, and establishing what's called an accident prevention program. So each work site needs to have a plan that is written down that's specific to the type of work they do. You know, what does the factory look like? What does the workplace look like? What are the shifts? What kind of jobs are done? And develop a plan that's specific to that work site. And that's supposed to be available to workers, which makes sense because if workers don't know what the plan is, it's probably going to be difficult to actually use it in a meaningful way. I will say that something we see a lot is that the plan sort of being buried in a desk somewhere. So I think we try to talk to people about the training they got when they were hired. What job did you have? Did you get training for it? It's very common that people will tell us, like I've spent a lot of time in Yakima in the last 2 months, a lot of people get trained by one of their coworkers on how to do their job, which depends on your coworker, right? Like how effectively you're being given all the information you need about how to stay safe. And then are people reassigned to a different job? Do they get new training? And so that accident prevention program is not just company-wide, but also what is the specific job the person has? What are they asked to do? And are they given the information they need to do that safely? And a lot of times when I talk to people, the answer is, I've never heard any of these things. I didn't get training. Somebody, like a coworker, trained me, and then I just get shifted to a new job. So we're hearing this a lot. There's a couple other standards. Again, none of these are new. This is me just telling you what's been in WISHA for a long time that I think are particularly relevant to the types of questions we're getting right now. So there's supposed to be a safety committee that has both representatives from the company as well as worker representatives that meets regularly, identifies issues, and comes up with a plan. So there should be some meaningful worker participation opportunities. Frequently we see that's like management only, and then potentially just like one person who's asked to come in, and you can imagine the power dynamic in that space. Another core rule that has existed for a long time, which for sure we're getting a ton of questions about, is the employer obligation to provide personal protective equipment. Under the core rules, they have to do it for free. I have a lot of people who are paying for their own masks right now. And they have to do it for free when there's a recognized environmental hazard. I think it is fair to say that the pandemic and COVID-19 is for sure a recognized environmental hazard, especially given what we know about transmission. And something I want to say about PPE is that in all of the training also that Dash does, PPE is actually in the hierarchy of interventions quite low. It's the least effective. We should do it, but there's much more effective interventions that we have to control hazards. And so when we talk about social distancing, cleaning, splitting shifts, letting people go home and paying them so that they stay home, there's other practices that companies can adopt. And some of them they are required to already right now that are much more helpful. PPE is important. I don't mean to knock it, but I just want to keep it in context. There's also some core rules around providing access to drinking water, providing access to bathrooms, not just bathrooms on site, but bathroom breaks, people being allowed to actually leave their work. And then access to clean washing facilities. Again, these are all things that are well-established requirements that I think right now are super important to people. As we're saying that we need to keep our distance, we need to keep areas sanitized so people are working, and we need people to have access to hand washing. So I think a lot of people are coming to us and just assuming like the answer is we're in this no man's land, we're in this pandemic that no one could have anticipated, which is true in a lot of ways, but there also are established legal protections that I think we want to be letting people know that they can use. Okay, so as always, there's other resources to look at. There's the industry-specific standards, which get more into the detail about like particular agricultural industry, construction. There's a lot of material there that may give some more specific guidance on practices. And then sometimes DOSH issues directives that further clarify expectations. So there's not a COVID-specific standard that has come out, but as we go through these different phases of reopening, LNI is working with the governor's office on different industry-specific guidelines that are coming out about how to reopen safely. And they also, those guidelines say that they're within LNI's enforcement authority of WISHA, which is to say that they're taking into account the other expectations and should be considered consistent with them. So lots, I'm sure there's like a lot. I also just want to say, safety and health, like WISHA was not something that our organization focused on historically. So I think probably a lot of people are feeling the shift where this is coming up for people in a pretty profound and like quick way. And so if you have done employment cases before and you're like, WISHA, this is not something I was thinking about, you're in good company. And we're all, also trying to absorb a lot of new guidance really quickly to try to figure out like what's the best information to give people. So WISHA is an important tool for us right now as we're talking to workers. Okay, you can file a complaint with DOSH. I want to make sure we get to that. So that's with LNI. I think also there's potential for people, in addition to litigation, to file a complaint with the governor's office. I think some of the practices, the safety and health issues people have are violations of the governor's COVID-19 proclamations, and there are mechanisms to complain specifically through that avenue. So with the time I have left, I want to make sure we try to get to some questions, although we can also do them at the end. I want to talk a little bit about the labor and industries complaint process. There are, like I said, litigation is for sure an option, but I think especially for the advising you all are doing, helping people know how they can file a complaint with the agency is probably one of the most accessible enforcement tools people have. So labor and industries regulates wage and hour issues, health and safety. They also manage a workers' comp system, although we're not going to deal with that. We're not talking about it today. But people may come to you, and that might also, a workplace injury may be another part of the experience they've had at work. So we have wage and hours as the wage complaints, and then we also have safety and health. I'm going to walk through each of them. They both have both a one complaint process for the underlying problem. So I didn't get paid, or there's standing water where I work, and they have a separate complaint form for retaliation. So they're important to know that they're distinct, because people get confused. They might not know which one to file or the order to file them in. So the workers' rights complaint, that's for I didn't get paid. I'm not getting paid overtime. They're taking things out of my paycheck, and a host of other issues, but so related to payment, not getting my meal and rest breaks, that kind of thing. People have 3 years to file those complaints. That tracks the statute of limitations in the Minimum Wage Act. Labor and Industries has 60 days to investigate a complaint. They have the option to extend it. People should know that they often do in order to follow up. So when L&I comes to a determination, they either conclude they're going to do what's called a notice of assessment, which is a citation saying we've concluded that the law was violated, or they determine that the employer was compliant, which is to say that there wasn't the violation that the worker thought was happening. So the citation is a win, right, for the worker. So that's a judgment in favor of the worker, and so a worker has 10 days from when they get that decision from L&I to decide, do they want to elect to use the agency process so that decision becomes final and then they go into enforcing that judgment, or do they want to withdraw it to be able to pursue litigation potentially? So people should know there's deadlines to file, but there's also deadlines to decide what you're going to do once you get a decision. And in both this and in the safety and health context, the deadline to file the retaliation complaint is much shorter than the deadline people have for filing the underlying, the complaint about the underlying issue. So there's a wage complaint retaliation form. People can file this even if they didn't file an initial complaint, so they can experience retaliation even if they don't have a formal labor and industries complaint for that specific issue. They have 180 days, which can be extended, but you have to explain, why tolling should apply. And again, L&I has 60 days, can get a little more time. Something that's good about the wage complaints is that L&I has made it possible to apply online. So there's a form, but they also have created like an online form that people can fill out, which I think is pretty good. Here's some things to think about with this particular enforcement tool. It's a process that is intended to be accessible to pro se. Sorry, folks, I keep like moving my screen. I'm not sure if you can see that. It's intended to be accessible to unrepresented people. So investigators are used to working with people who don't have attorneys. A wage complaint filing tolls the statute of limitations. So it's important for people if you're working with someone through the clinic who might be interested potentially in litigation, and that's probably beyond the scope of what you're doing, filing that initial complaint can be really important for people who might otherwise be time barred if they're getting close to that 3-year statute of limitations. There are some, not limitations, but just things to be aware of. Is L&I, obviously, there's a ton of need and our enforcement resources are always limited. So there can be some pressure, which can result in investigations maybe taking longer. So people should know that. And then one of the things that happens in any enforcement context when you're working with workers is it's possible you're going to get a judgment that you can't collect on. And so that certainly can happen even with the L&I processes. You might get a good citation, or the worker might get a good citation, but L&I has limited resources to help make sure that money's collected. So that's just something to be aware of when you're talking people through that option, because it can be really resource intensive. If people have ever been in collections in any of your other practice, it can take a lot of time. For workers who live in Seattle, the Office of Labor Standards is the city counterpart to Labor and Industries, and they also can enforce wage issues. So that's another enforcement option. And then small claims court can accept claims up to $10,000. So especially in our experience working with low wage workers who are owed significant amounts of money for them, but that are under that cap, that can be another good option. And again, that's a forum that is accustomed to working with pro se litigants. And they can still ask not just for the money that they're owed from their wages, but also for any penalties, damages that they're entitled to under the law, interest. They're still allowed to pursue it through small claims. So I just wanted to share that as another resource that we think about. Okay, safety and health complaints also go to Labor and Industries, like I said, to DOSH, so a different part of the agency. There's the underlying complaint. Again, you have 180 days to help people file that. DOSH has up to 6 months to another 180 days to investigate, although they do say that they try to at least get back to people within 30 days. And then the discrimination complaint. So this is a little bit confusing because they call it discrimination complaint. I think it might be helpful to think of it as the retaliation complaint. It's retaliation just for an issue that DOSH has jurisdiction over, right? So it's going to be a safety and health thing. Other discrimination people are experiencing, I think Colin's going to be talking about the EEOC and the Human Rights Commission process. So sometimes people have a variety of discrimination experiences, and some might go to a different agency. So this is retaliation when you've raised a safety and health concern. And so this has a very short deadline. All the deadlines related to these complaints for this particular complaint are short. 30 days to file from when the discrimination happens, generally strictly enforced. Shorter timeline for DOSH in terms of how long they can take to investigate. And then if DOSH concludes there's no discrimination, there's a worker, if they want to pursue a claim in court, has only 30 days to do that. So that's, it's pretty time sensitive. So to the extent that you're working in a clinic that's helping think about referrals or connecting people, good to be aware of that, and certainly good to be aware of that as you are walking people through. Something to know about the safety and health complaints, which is different. They each have a pro. Like the wage complaints have the pro that you can do the online form. The pro of the DOSH complaint process is that you can also make them by phone. I think I haven't done that a ton of that, but it is good to have another option, especially for people that have like an imminent safety risk that they want to report. Oh, that's it. So that was the material that I wanted to cover. I know there were a ton of questions. I just want to skim them, but Michael, I'm also conscious of time. So you should let me know if you think it would be better for us to do that at the end.
Yeah, we have about 10 minutes left. So if you want to answer questions for maybe 10 or 12 minutes, and then if we have any left, we can move on to the end.
Yeah. Okay. So there's a question about, do I have resources about misclassification? For sure. Yes, we could definitely share that. I'll try to see if I can put some in the chat just while we're doing the other presentations. So Washington uses the economic realities test, and I'm happy to share the link to the case that goes over what that standard is. Yes, happy to share more about that. Oh, and how do we decide if they're actually, yeah, okay, so sorry, more on classification, I'll share that. How enforceable are policies in an employment manual? Definitely, sure, I think your point's well taken, Robert, but I think it also goes to what they've put out as the practice, which can often be helpful when people, when there's a dispute between the employer and employee. So anyway, yes, I think it's a helpful tool, doesn't tell the whole picture necessarily. Protection from retaliation. Yukiko, I'm not sure now. You might have to tell me if you asked that question, maybe when I was going over the wage thefts, the Minimum Wage Act, so that if that's right, that only covers employees. And so the retaliation protections through that act are going to be more limited. But there's definitely just protections for workers in general who raise concerns about workplace issues. So in that sense, there may be some avenues, even if people are not entitled to the underlying protection of minimum wage, for example, the protection against retaliation. So, but that is going to get a little bit to what remedies people get afterwards if they're not entitled to the underlying standard. Okay. Questions about overtime. Oh man, Eric, you have a specific question about the offshore limitation of OSHA. I have to tell you, I don't know that off the top of my head. I would be happy to look into it. Yeah, so how does Natasha has a question about an employee showing discrimination in firing when there hasn't been an explicit overt actions. So difficult. And I hate to punt, but I do think either Colin or Allison is talking specifically about discrimination. And so I think that I'm going to let them take that one, because yes, it is really hard to show the motivating reason for conduct. It is a challenge. And I think we all know that there's conduct that happens that often can be motivated by discriminatory intent, but that it's really hard to actually show what you would need to make that case in court or legally. So then we have a question about forced arbitration clauses. So that, again, Ruth, that's also an excellent question. I would love to know if either, not to put you on the spot, Colin, but I don't know if Colin or Allison, if that has come up or if that's been something that you have thought about. If it has, would love to know your thoughts about ways to get around them. And I'm just saying, do the WISHA WACs include evidentiary standards for proving violations of the general duty? Oh, Jason, another excellent question. I have to say we have not gotten to the point where we've been considering a tort claim. So I want to think about that. If people want to send me their emails, I would be more than happy to continue chatting with you about these questions. Feel free to send me a message. I'll also just put my email in the chat. I'm sorry to not answer everything, but I would rather say I don't know than give you some information that is not accurate. And then there's other questions. I see another question about overtime. Exempt and salaried employees, when it comes to overtime, can there be salaried employees who are entitled to overtime? So I would be happy to share, and Michael, I could even send this. I'm not sure what our plan is in terms of distributing the presentation materials afterwards, but there's some great new resources talking specifically about the raised overtime threshold in Washington, and what that means for workers, and in what scenarios might there be workers who are salaried who still are entitled to overtime. So I'd be happy to share those.
Thank you, if you can share them with me, I'll include them in our post content distribution. Yeah.
And then I'll just say, I didn't talk about this a lot because we wanted to focus on the administrative process just because of the more limited advising that might happen through the clinics. But I just got another question about what recourse people have if they feel forced to quit because an employer doesn't comply with safety standards. And definitely one of the things that we and other colleagues in the plaintiff's bar have been thinking about is whether it's the WISHA standards generally or some company policy that seems contrary to the guidance that we're getting from the governor and from the agencies in the context of the pandemic, to what extent that includes constructive discharge or wrongful discharge in violation of public policy. So thinking about some of the other common law claims we have, because we're certainly seeing a lot of that. And I think some folks are working on some demand letters and complaints along those lines right now, because it definitely is something we're getting a lot of questions about that. And I would have to imagine that you're going to be getting questions from people, in particular as businesses start opening again and people's unemployment benefits start running out. I think more and more questions will be coming to us about how do we refuse work that we think is dangerous.